really say it. And I want to put my disclaimer here to protect the legal liability of the person speaking in the video. I just want to protect myself, the intellectual property, and the integrity of this community. I want to clearly state that I am not an attorney or act as an attorney. Any information material shared with you in this video is to offer you guidance and is for educational purposes only. In no way do we promote fraud, deceit, or offensive content. I shall not be held liable for any conduct, any content of any party viewing this video. So any decision made based on such information, you guys, it is important to do your due diligence. This is going to be based on, of course, marital and relationships and just kind of coming together. But again, if you're not married or if you're single, hey, you're looking into it, just kind of take heed to the information and it can be useful for someone that you know. So navigating wealth and a family dynamics and blended families, sometimes in today's society, blended families are common, but sometimes it could be misunderstood. Now, hey, I'm not about to sit here and give you no relationship advice. This is just going to be a conversation that should be held. Some may choose to do like marital counseling and relationship counseling before they get into this type of relationship. Rather, if you're saying, hey, I'm invested in this and I want to protect my assets. So when the wealth is involved, navigating families, dynamics, and financial planning can become complex, right? So open and honest communication. Sometimes people tense up when you got to talk about money, right? When you're coming together, maybe about to move in with each other, start a business, or again, putting a trust together. This is the main concept of us talking about this topic, because if you're going to get into a relationship, I always say this, and this is like one of my statements or quotes, love is free, but marriage is a business, right? So, of course, the honest communication. How do you feel about your financial plan? It is crucial before getting married. Okay, so marital estates depends on several factors, again, including state laws. Whatever state you guys are tuning in from, I do want you to definitely look into your state laws. Also, the timing of marriage, that plays a part, right? Because if you're like, hey, I've only been married for less than 30 days, right? Or I've been looking to get married and I want to have these things added to, maybe you have assets before the marriage. So we're going to get into all these different complexities, right? But learning this information should open your eyes when building like a trust or setting the right foundation for a healthy marriage, or should I say even a healthy blended family, even if you don't get married. Now, a private trust structure is also important, right? Because there's different types of trusts, right? It could be revocable and irrevocable. All right. So then this session is geared to help you understand the challenges when wealth is present in blended families and how to address with effects and strategies, right? Effective strategies. So let me also say this. Before you get married, I've seen in so many different scenarios and situations where you can be in a relationship for a very long time. And we use things like, oh, that's a commonwealth marriage, right? I've been married to this person for so long. We don't need to get married in order to have those responsibilities. In some cases, that is true. In some states, that can be helpful as well. But let's look at the breakdown of to heirs, right? So what happens is if you get married or if you don't get married, of course, based on state laws, if you had assets, how does it get trickled down to heirs? This is why I wanted to show this, right? Now I had to put numbers under there to make my lines go, so don't pay attention to the numbers. That's not money or anything like that. But an order of intestate succession. Now, this is based on if you don't have a trust. The reason why I put trust at the top of this example is because it outweighs any other factor. All right. Now, some people, they may put a trust as a beneficiary and things like that. But let's look at the breakdown just in case if you don't have nothing in place and you're in a relationship. All right. So spouses. Let's look at one. Spouses receives a portion or can be the entirety of an estate, depending on whether there is a surviving children or parents. And we see this a lot, even in celebrities, right? Or even in just maybe your family. Maybe you have a Me Too moment and you say, man, I thought it was going to go to so-and-so, but it did not based on them still having like maybe a surviving parent. So let's break this down. A person passed away. If they are not married, the next step is it goes to their surviving parent. If they are married, right, then it will go to the surviving spouse, okay, or the widow, right? Now, if the person is not married, or maybe they are a widower and the parents are not surviving, then it will go to the children of the decedent. Now, let's just say that person don't have any children, right? So it shares the remaining of the estate equally. Of course, if you have more than one children, equally shares. If the spouse did not receive all, okay, if the child is deceased or the children, excuse me, I'm going to add some people. If they're children, of course, the deceased will go to the grandchildren. So inherit by the right representation. So you keep going down the line. If you had children and then that children had children. So I want people to understand, like, even if you're in a relationship and it's serious, it's committed, and there's some outside children, or if it's blended children, you got to pay attention to that, because when you get married, it says all power vested in me. It's not the person that married you. It's the person that is state licensed. The state used an individual to represent the state. You are marrying the state. So then through marriage, guess what? That child that belongs to the married person, right? Or the spouse, should I say, that child can also be added to consider your children, or it used the proper term, stepchildren. All right. Please drop a 1 in the chat if you're picking up where I'm dropping off so far to where we're at to 2. So if they have children, then it goes to, oh, well, it's the surviving grandchildren. All right. This is important because if you don't want it to start going down these airs and it starts spreading out, right, like a wildfire, then you have the right to control where and how your wealth will be passed on. Okay. Now, the parents inherit it if there's no surviving spouse or children. Okay, because we have some people that will watch this video that say, I don't have no wife or kids or husband or kids, right? So now that parent, now the siblings, let's just say that the parent is not surviving. There's no children, right? There's no spouse. Then it will go to their siblings, right? So you may say, I'm not married. I don't have any children, but I have a brother or sister. Maybe you got multiple. And in my family, it's 10 of us, okay? And that could go a long way. Now it's unfair, right? Because you go, I got one house, I got one bank account, and now you got to spread it amongst 10 to 15 children, depending on the size of your family. Now, if it's just one, then that's good. They'll have that complexity. Then you know how to break this thing down. But let's just say if the siblings is deceased, then they had some children. That means it goes down to your nieces and nephews. Now, when it says inherit by representation, that means it may show a birth certificate. It may show some, information that shows the connection to the relatives. Now, if you have to deem some type of control or transfer from an estate utilizing your proof of family, proof of resident, proof of, I'm thinking a word. Yeah, your family, right? Heirs, that's the word I'm trying to say. Proof of your heirs. Then again, they may ask to show some certain details. And this is a honest to God truth. I witnessed it. There was a situation, I'm sorry, I'm stopped at 4 for a second. There was a situation that, let me break this down smooth. The young lady stepfather was survived, like he survived, right? The mother was deceased. So what happened was the child was the stepchild to this man. He died and left all of his assets to the stepdaughter, right? But guess what happened? Throughout this 50 years of marriage, the original children, meaning his biological children of the step, never came to the forefront until, what did the stepdaughter do? She was just being fair. She said, I haven't never met them, but all I know is he has these children. She put the children in the obituary. Let me tell you what happened. They used the obituary to now split the heirs They split it, right? Now the stepdaughter, right? She took him to every doctor appointment. She was power of attorney. She was all information on all paperwork, signing and approving everything, right? Even on a joint bank account. But guess what happened? Because the person passed away, it can't be possible a joint bank account. It turned into a single because the person is only one person surviving. This is how we learn, unfortunately, on the other side when a situation happens. Guess what happened? They had to go through court. She said, I haven't seen these people. I've never even met these people. So guess what the judge said? Well, why did you put them in the obituary? She was like, because I thought it was the right thing to do, but that gave proof to trace and track. Now, when it comes to someone contesting the estate, and you have to break down, this is why a proof of representation, guess what they started showing? A birthday card 50 years ago. That's proof. If that was a birthday card that came from their dad to say happy first birthday, it was proof. It was solidified through the courts. If they had a birth certificate that say, hey, he's on the birth certificate, he ain't been there, but it's proof. So I want you guys to start really internalizing why we started, and if you guys are in the live in the trusteeship enrichment program, why we start moving everything to a business, operating as an entity, separating ourselves, because the wealth as we build is totally separated from your estate. All right, now let's continue to 5. Now let's say when it comes to the maternal and paternal, when it comes to the parents from either on your mother's side, your dad's side, this is now it still expands. If there's no spouse, no children, no siblings, now it goes to the grandparents. Okay, the grandparents may inherit. Now again, if not, then you go to your aunts and uncles. If not closer family exists, inheritance can be passed down to aunts and uncles. And guess what else can happen? If the aunts and uncles have children, which means that'd be your cousin and them, okay, it gets passed down to them. And then after that, you guys, it just continue with distant relatives. The inheritance may continue more than distant relatives such as cousins. And guess what? If you feel as though you can't even find them and you had no other family, because I get people that say this, what if you have no family? Guess what? It goes back to the state. And it's considered escheatment. Now, if you never heard of escheatment, you ever hear somebody say unclaimed, right? Right? No heirs can't be found. The estate typically goes to the state or the government. Guess what comes in? You got your auctions, you got your wholesalers, you got all these strangers coming to swindle and take property from your loved ones. Why did I choose to break this down first? It's because when you have a trust, and maybe this is your situation, this is the reality of it. You may not have family. You may not have all this extended cousin. And if you do, and you may not know based on your ancestry.com, right, or your genealogy report, right? This is considered knowing who you are and who you're connected to down your lineage, right? You still can utilize the trust to dictate and control. Now, if you say, you know what, I don't want to give assets back to the state, I want to create a foundation. This is where it goes back to putting it in a foundation. Hey, if I meet a lover, finally I'll get to have a family, right? Now you can decide whether what I get into next is going to be beneficial for you, all right? This is why a trust can be more powerful than a prenup. I hear when you talk about relationships, prenups is like, oh no, somebody's trying to use somebody or take somebody for their money. It's always used in a negative sense, right? Or I've seen so many different situations where someone had a prenup and they still lost assets. And how does that work, right? So yes, marriage is beautiful partnerships, but it also can carry financial implications. While prenuptial agreements are common tools for asset protection, which we say it does protect in the sense of assets, right? But trust offers more power, more security in a way to protect you and your assets from potential risks, even including divorces, right? Because see, when it comes to prenups, it's still not going to really protect in the sense of like child support or like alimony, right? It kind of really plays a dynamic factor in like, yes, we are getting married. You're identifying that, hey, I came in this relationship with this, you came in this relationship with that. But what if you obtain assets while you were married? right? Now that's being deemed as community property or marital assets. So let's break this down. Protection of assets. Now, marital property is subjected to a division if there is a divorce. Now, by creating, or if you create an irrevocable trust, which we talked about this, it keeps assets legally separated from marital estate. Can anyone that's live in this session tell me why? Right? So put it in the comments. Maybe if you are watching a replay, write it down in your notes. Okay. Why will an irrevocable trust keep assets legally separated from a marital estate? Let me see if I got some in the comment section while we live. The grantor does not own anything because you don't own the assets. I like the answers. How about when you transfer assets out your name? That is a great answer. Let me see, I got one more. If it's an irrevocable trust, it's not in your estate, and therefore it's not a marital estate. That's the one I was looking for. Yes, shout out to you, Cashrell. All right, so that is the answer that I was really, really looking for, because yes, that is true. You don't own it. It's not a part of you being either husband or wife, or just spouse for that matter, right? But if it's not in your name, not an ownership, which everyone was saying, then it's not a part of your marital estate. So, hey, here's the good part. When you're getting married, there's no fear. There's no like crocodile hands, right? There's no crocodile arms where you like short and be sure if you want to get married or not. You can still go into this agreement, which is still a business agreement when you get married, but you can keep things separated because they're not in your name. All right. So when you give up that ownership, make those assets inaccessible in the divorce. Now, let me put my disclaimer here again. I just want to reiterate that this is not legal advice, but I do want to share what they don't want you to know. All right. So this prevents assets like real estate, business interests, or inheritance from becoming part of your marital estate. Do you not understand? I have seen in my time, okay, helping other people, that I received this house from my great-great-grandmother. Yes, it was transferred to me. It is in my name. Now I got to split it with my ex-husband. Now he get to, have either I got to sell it. Now you taking it out of your lineage. You can't pass it on to the ninth generation because it somehow got caught up in a marriage. Drop a heart and a chat if you pick it up what I'm dropping. Right? So here's the clarity. When it comes to this, and transparency, the trust can ensure that the business can remain operational and intact, regardless of a marital change, right? So neither the husband or the wife own assets, so it won't affect the flow. Now, we've seen this with Kanye West and Kim Kardashian, right? They actually have a marital trust. But see, there was a situation, an underlying situation where she said, please, Kim Kardashian said, please deem me single. Please deem me single. If they deemed her single, then she could do any and everything that she want with her portion of those marital assets. Why? Because the trust is 100% the owner. Okay. Now, when it comes to marital trust, you still don't own anything. But what's happening is you both have equal controlling rights. All right. So you can define the roles in managing those shared assets. You like, look, we ain't together no more. But when it comes to this house, if anything happens with this house, we split evenly. Now, sometimes divorces are not amicably, you guys, but I can't tell you if you ain't gonna have no drama. All right. But this is giving you an insight on how to go into this relationship, how to go into this trust agreement, how to dictate, should we put this asset in here? Hey, maybe that's your business venture. I don't want no parts of that business venture, and so forth and so forth, okay? Potential for conflict. Couples can specify how and when income generated from trust assets is distributed, helping to avoid financial disputes, right? Please take notes. Primary trustee and co-trustee have shared roles and power, right? So negotiations can be challenging and may create tension and conflict between the partners. Couples can specify how and when income is generated from the trust assets and distribute and helping avoid financial disputes. Now, the reason why I added this is because sometimes you may have a blended family with children. And if you are the trustee, co-trustee, sometimes you may put, hey, I came in this relationship with 2 children. Hey, you may came in with 1 child. You may came in with 3. I came in with 2, and guess what you guys did? To make it an even playing field, we put our children collectively as successor trustees, right? Now, this is a decision based on the partner that you're with, okay? Will it work? It can work because you still don't own anything, all right? Now, legal challenges. Trust offers privacy, unlike prenuptial agreements, right? Which may become public record during the divorce proceedings. If you have a prenup, now I've seen in some situations where you can put the trust inside the prenup. Let's say, you know what, I already got a trust before we got married. It may be revocable, it may be irrevocable. Assets are already put inside the trust. That don't mean you go and start taking everything out the trust, putting it in the other trust, right? You can still keep it separate and say, I would like to put that trust aside the prenup. There are people that still choose to have prenups. I don't know why, because trusts are more powerful, but sometimes people add the trust inside the prenup. What I will say is prenuptial agreements must be legally sound and meet the specific requirements, can be enforceable, but to tell you the truth, prenuptial agreements can also be changed. And that is based on how the judge may see fit, right? You have infidelity, they have restrictions, right? Sometimes they may have like, oh, if you were to cheat on me, if you were to do this, then you get nothing. Sometimes it has subjected to change due to certain situations. But again, I'm not here to get into the intricacies of prenups. I just want to share with you how you can still benefit by being married and have your assets separately, how you can run it like a business and keep it away from divorce risk. All right. So the trust give you more security, and also for those children and blended families if you choose to do business with those children. Sometimes I use the term children, but they could be adult children, right? They could be adult children with their own children and their families. So the way that I showed you of that chart, how it could start trickling down and start going wide, start opening it up to other family, right? On either maternal or paternal side, right? That's where you want to pay attention to when you get married, all right? Challenges of previous wealth added to marital trust. I see this all the time. One of the biggest mistakes is that I've seen when helping with trust structure is blending assets into the trust after you get married or after you've gotten married. All right, so if you have assets prior to getting married and it is automatically treated as separate property. Now, however, if you add those assets to the marital assets, right, well, add those assets with the marital assets, now you're mixing, right? And then now they're going to become subjected to a division and when it comes to a divorce. And now you sit up here, but I had these things prior to. Well, you added it to those particular trusts, if that makes sense. This is still, I know we're still talking about marriage, irrevocable trust, but I'm giving you the dynamic because sometimes when it comes to state, you are still married on paper. And if you have a revocable, again, with irrevocable, you want to make sure that these assets are not added to something like a marital trust, because marital trust is what it states, married together, all right? So that's the only reason why I'm reiterating, because you may put an irrevocable trust inside a marital trust. And guess what? That will be subjected to the divorce. Why? Because now you added and commingled and mixed it. All right, so pre-existing assets. You have assets before you were married, like, of course, a family home, investments, inheritance. Keep it separate in case of a divorce. You then, right, turn around, get married, and acquire new assets like property together, trust-owned bank accounts. Even though it's not a joint account, maybe the trust is the owner. You guys have shared your signatory roles, things like that, or businesses, the trust is the owner, and you guys are on there as like collective presidents and executives, something like that. Like you don't own it, but these are the marital roles that you are not the roles that you put inside of this marital trust. The solution is create just 2 separate trusts, right? It's okay. You still can be married. You still can be and so in love on a honeymoon phase, right? But premarital trust, this will hold your assets from the marriage. Separate property this way, and the marriage ends, these assets are protected. Marital trust, this trust will hold assets acquired during the marriage. There are some people that still want to do things together, okay? But again, for those other outside children, stepchildren, grandchildren, step grandchildren, you may get a bond, like very, very close bond that you say, you know what, I don't even say step. I say bonus babies, right? I look at them as my own. I love them as my own, and we all share this equally. There are some marriages that will just like to operate that way, but you still got to think about it as a business. Am I saying that you're like always on the brink of what if this don't work out? What if this is a divorce? What if marriage is a business and things happen? I am a divorcee, so I can speak from a situation personally. And just to put on a record and recording, we're getting married again. So, but we're not getting married to the state. Why? Because of experience. And for those stepchildren, biological children, and if you have children together. So let's say, remember, if you started off in this relationship, maybe you had one over here, you had two over here, but then you have some together. Now that creates a dynamic, right? You don't want one child to feel like you're taking favoritism of the other child. And that's why sometimes, again, this is based on complexity. All right. All right. Now, yes, when it comes to, oh, hold on. Now, when it comes to everything else, like as far as how you're going to structure your trust, that will solely be based on your relationship with the person. Okay. Can you do these things? Yes. But I would not recommend any relationship advice. I would not recommend anybody like, I'm not going to tell anybody what to do. This is giving you guys a guideline. Hopefully that helps you out. All right. Now, the challenges of well-blended families, different expectations, right? You like, first of all, this is how we operate. I'm a family-oriented person. I love hard. We don't see no separation. We don't see, half this, half sister that, right? Sometimes you're raised different. You have these traditions, right? But other families like, nah, I love you, but that's not how we move, right? Everything separately. I got money tucked in the savings that they don't even know about, for those that have that secret account, right? So sometimes step families often bring varied expectations regarding wealth, inheritance, financial contributions. These differences can create tension and resentment. So the good thing is start off with an even playing field. Find out your childhood traumas, your triggers, right? When it comes to finances, because guess what? That plays a part. Past relationships, right? Oh, this is my second marriage. Oh, I've been divorced before. Oh, this person took me for everything I have. But it's unfair. There's a saying that I always say, especially with dealing with this kind of business. I am always healing a heart that I didn't break. And it's unfair. But I'm always in that position, right? I'm trying to understand. Oh, I don't like this. This person did me wrong. Oh, I had a bad mentor. Oh, right? Now I got to mend your broken heart and I ain't even break it. And that is also how people go into the next relationship saying, hey, I got to protect my wealth. I don't want to share. It is just about having a conversation, an understanding. Because if you see this as longevity, you still can operate in decency with integrity, and you can protect the business structure. Create a certain model that benefits us all, even if there was a divorce. All right. So past relationships, pre-existing family dynamics, right? Again, trauma bonding can also create complexities that affect how wealth is handled and distributed, or how it plays a factor in, will you be a co-trustee? Should you just be a successor trustee? Maybe you should not have controlling power. Maybe that makes it fair. That's not stating that I don't trust you financially. This is why if you guys are learning this in this program or watching this video, it's helpful to share this information with your loved ones. All right. Financial transparency, ensuring transparency and open communication regarding financial assets and future plans. Maybe you just need to sit at the table and say, I don't know what I'm doing, right? I don't have all the answers, but let's come up with something that is for us, by us. Oh, that sounds like FUBU, but you know what I mean, right? Come up with your own instructions. That's the beautiful part about expressing your own trust. writing out your instructions of how exactly it will look for you. That's why I always say there's no cookie cutter type of trust. Right? If you say, you know what, I'm going to have one account over here, I'm going to have another account over here. One trust is yours, the other trust is that one, and then we're going to have one trust in the middle that we both build. That's still fair on an even playing field, right? So future plans is crucial for building trust and minimizing conflicts. And the only reason why I say that because we can never say how you're going to act in the future when it comes to money, right? Some may make more than others. Some may feel entitled. That's a word that'll really take people over the hill. Oh, I'm sorry. All right. Now, how an irrevocable trust can protect assets. When it comes to asset protection, you guys are understood. Irrevocable trust removes assets from your personal and marital estate, shielding them from potential claims like creditors, lawsuits, and divorces. So when you are setting up the trust and you're like, hey, I want to build this for blended families. I want to operate this trust when it comes to maybe we are getting married, but we don't have to show in real time that we own anything, right? So you still want to have that asset protection first because it's not just about divorces. We still got to pay attention to the creditors. We still got to pay attention to lawsuits. Sometimes you look at when you have a creditor, they're trying to go after the spouse, right? You be like, well, we did join as one. That's why they tell you, you are now joined as one. You share debt and wealth, right? You like, man, that person left me with wealth. I did see something publicly in an article. And the lady said, well, for you guys' knowledge, my husband left me with ample amount of dollars of debt. But if they know, like they know, if they was in the trusteeship enrichment program, debt is not assumable. You can't just go passing on debt to family. That's only if they have lack of knowledge. And guess what? They accept it. Submission of guilt is one of the #1 reasons why there's confusion, complexity, and assets are being taken. You said it was yours. You took on the responsibility personally. Estate planning, they allow you to control how distribute, talking about either the trust, right? These types of trust, irrevocable trust, allow you to control how assets are distributed and managed after death. So even when we talked about protecting the estate, you don't have to pass it to the estate. You can ensure that the assets are managed through multiple successor trustees. You know, I did a video before that shows the baton. You're passing the baton through generation after generation after generation by just the trust owning everything and always having a signatorial role after your death. It's like you're still telling your story beyond the grave, ensuring your family's harmony, ensuring that your successor trustees keep the wealth in the family. And that creates tax advantages, right? Because if you're not distributing it, you're not taking assets out the trust, that protects you when it comes to having to file taxes, right? So an irrevocable trust can offer tax benefits, minimizing estate taxes. If it's not a part of your estate, then you don't have an estate tax. Minimizing distribution tax to your beneficiaries. Let's just say there's a trust as a beneficiary, or maybe your estate is the beneficiary. Well, we don't need to pass it, right? Or distribute it to these different entities if we keep it running. If we keep it running, that means we're deferring how we're going to dump it out or take it out the trust. Hopefully y'all picking up what I'm dropping. Please drop a 2 in the chat if you're following us far. We get ready to wrap this up. Perfect, perfect, perfect. Now, when it comes to what if I did get married? What if we got a divorce and maybe this person is a successor trustee, or maybe this person is like a co-trustee? Like, how do I remove this person? How do I add this person? Like, what is am I stuck, right? Do you like go through this divorce and then you just leave the person in the trust? This is why understanding your roles and power. Just because you are the grantor, the one that gave up control over the assets, we cannot forget that you created the trust. You set out instructions for the trust. You had intentions for this trust, right? But that situation may have changed, right? So adding and removing trustees to an irrevocable trust. Now that trustee appoints the agreement. Why did I want to make sure that highlights? Because the grantor is not making the change. Whoever the grantor appoints to be the trustee can make the change. Now, if you say, wait, Layla, I'm the trustee of the trust, but are you doing it in your natural capacity? No, because when you put TTEE on the back of your name, you've now inflicted your role of power. You're not doing it as your natural capacity. So that's not the grantor making the change, right? That is the trustee that is making the change, right? Just in case if you go back and say, well, I don't have no spouse, I don't have no children, it's just me, right? So maybe you put an entity there. All right, maybe you have a trust there. Maybe you have something there that continues to operate this trust. This agreement, this is an example, you guys. So this is kind of like an example, if you will, what it looks like. This agreement is made on February 10th, 2025 by undersigned parties regarding appointed of a successor trustee for the, and then you put the name of the trust. Now, if you had a trust that was created before, of course, use the original date of this particular said addendum, or again, the agreement of why you want to add or remove a trustee. So this is what you want to recite, because why are you creating the new appointed trustee? John Doe, the former, whoever you're removing. So let's say it's an ex-wife, ex-husband, spouse, whatever the case may be. The former trustee has resigned, taking effect on, let's say, January. And again, in my situation, you guys, if I had a divorce decree, that would be my proof of documentation why I'm no longer going to have the spouse inside the trust. That is the proof dated on that date. Maybe the person is deceased, right? Now you want to remove that person. You don't want to have a person inside the trust if they're no longer living. Things change, right? Maybe a child is born, right? And these are the recitals. So these are all multiple situations. We say, oh, we had some children together. Oh, now this is my bonus baby. I want to add them to the trust, because again, it's based on what you choose to do. All right. So that date will be effective as in what the scenario or the situation is. Now, you, on the other hand, could be the person that is appointing. So that means you have role and power. So I, Jane Doe, as primary trustee, even though it's not TTEE here, you're stating who you are as that primary trustee, all right, has the authority to appoint a new trustee under. If you have the declaration of trust, you should immediately show where the role of power the trustees have. They have in Article 3, Section 308 through 312. That may have a whole paragraph or, you know, certain couple of subsections that will tell you all of the roles and power that you have, okay? According to this section of the trust agreement, right? Boom, it takes you to that area. Oh, Jane Doe do have the power to add, remove, recommend, take the court, whatever that may be, okay? The appointed of successor trustee. I'm gonna say I, Jane Doe, appoints John Doe, okay? Now, I want to put the address of the trustee. Why? Because we want to make sure that the trustee is in the same state of the trust. If you are in another state, that very well may not be valid. Okay, so you want to check your state provisions to make sure. Now, if you want to add that trustee, all you got to do is have that trustee get a virtual address. All right. Hopefully that's a jewel that you picked up right there. Now, because you might say, well, what if I appoint an entity? All right, y'all, my trustees in this live session should be already aware where I'm going with this, right? So a successor trustee can be an entity or a natural person. So when we see residing, don't think that it's only related to a natural person. It can be a entity that is located in that state. If it's a business, if it's a trust, if it's, you know, so forth and so forth. You do want to identify that address. Okay, and that it is effective immediately. Okay, the acceptance, because guess what? Don't put somebody in the trust and they don't even know they in the trust. Okay, so then that person has to respond. I, John Doe, accept the appointment, right, as successor trustee of the trust and agree to execute my duties in the accordance with the trust and applicable to law, applicable law, because you want to make sure that they're following. Then you're not adding another trustee that's going to rob you, that's going to take advantage of trust assets. And then, of course, the signature of the the successor trustee, which will be added to as John Doe. They accept on that date. The acknowledgement by appointed authority. I, the person that appoint these individuals, I, Jane Doe, appoint John Doe as successor trustee, and then I'm going to sign, okay, as trustee, okay? Now, from the beneficiaries, this is also if you have a beneficiary. Again, if you do not have, it's optional. You don't always have to do it. Now, the reason why I say you don't always have to do it, because you can do this paperwork, get it notarized, and keep it in your trust to avoid any issues. If you have a state requirement that says it has to be recorded and it has to be accepted by the courts, then again, unfortunately, you have to reveal and show your trust, okay? Because it has to show that it has that power, all right? Now, you don't have to show the full details. You can show here just that article page and the notary page, all right? Also here, acknowledging by beneficiaries, again, that is optional. We, the undersigned beneficiaries, consent to the appointed of John Doe. That is the new successor that is added. People ask me, how do you get banker trustees added? How do you get trust companies or trust protectors added? These are other ways that you do this as well. We consider this as an addendum that is added to the trust that is already created. You may not add a banker trustee because maybe you don't have the money in there yet. You may not have a trust protector yet because you don't have the complexities. Maybe if you're getting married, it shows the complexities, and maybe you want to make sure there's a median, right? So somebody that can mediate on behalf. You just now get a trust protector. The same concept with all of these positions, okay? Now, the signature of the beneficiary. Again, I have it in parentheses for those that are more advanced than others. Maybe your trust is the beneficiary. Maybe an LLC is the beneficiary. Maybe your estate is the beneficiary, but if you're still living, then there's a signer that is connected to the estate of. Again, this is all based on the structure of your trust. Hey, if it's people or if it's other trusts, then you guys know what you have to do. This is why a sealed embosser sealed stamp is also useful and helpful, right? Because on that paper, guess what? Pop, you go ahead and stamp it, and then you can say authorized signer, all right? So hopefully that makes sense. And then you get the notary, again, of course, making sure that it is within that state, okay? And then you want it, of course, required with 2 witnesses. That solidifies it to make it legal. All right. Now, removing trustees from the trust. Reason for removal, it says there must be a valid reason for removing trustees, such as incapacity, maybe misconduct, or conflict of interest, or divorce. Maybe I want to throw that in there. All right. Trust document review. The trust document should be carefully reviewed to determine the specific process of the trustee's removal, making sure, according to that section, do this trustee have the power to remove, add, and things of that nature? When people say, oh, you cannot amend the trust is amending the actual trust structure. You're not amending the trust structure. You're removing a role, but you also replace another role. It still means that the structure have trustees, successor trustees. Drop a fire in the chat if you're picking up what I'm dropping, because we get ready to close out here. Right? So the court intervention, this is some cases, this is not all, you guys. It may not be just a complexity situation. You could say, hey, a person died. Hey, a person born. Hey, there's a divorce. There's no need to go taking it to court. Now, somebody went and stole something, now created some type of lawsuit, things like that, and you did not have no knowledge. Then it may have to go to a court process. These are different scenarios and reasons. Court may intervene or intervention may be necessary to remove the trustee, especially if there's a different disagreement. Guess what? Trustee gonna say, I ain't going nowhere, right? I ain't going nowhere, right? Now you got to say, okay, now we got to get somebody else involved. Now that'd be a reason, but you can also put it in writing that the trustee refused not to remove themselves under the disagreement. And again, the grantor is appointed a trustee power. So I don't want people to think that you're powerless because you had an irrevocable trust. Hopefully this information, you guys, bring clarity, help you understand the severity of when you are operating as a trustee, grantor. It is business. When you are all in love, right? And you love this person, and then you turn around and say, I was blind by love and I don't know what I was doing. you still got to move like a business. You got to think of this like a partnership. You got to think of this as, God forbid something was to happen, like a divorce, like a lawsuit, like someone passing away, right? So hopefully all of this that we talked about today will bring you clarity, help you understand how you can move, and also help you understand what's the next part when it comes to your legacy building.